The next case to come before the court is Garon Petty v. City of Lorain.
Your Honor, this is Mr. Petty and his wife, Jean.
Okay. Welcome. Counsel, you will have up to 15 minutes to present your argument. The arguments are being recorded, so please stay behind the podium and keep your voice up. You should not use the names of children or minors or victims should that become relevant to your argument. You can refer to those folks with initials or generic terms. And we have read your brief and the state's brief as well, and we are ready to proceed when you are.
Thank you, Your Honors. May it please the court. Your Honor, I would ask you to consider this case from the constitutional perspective. I'm sure as lawyers and as judges, we all agree that the Ohio Constitution is an apex law, and it must be followed. It must be followed by the state, by its municipalities, and in this particular case, the City of Lorain, Ohio's 9th largest city, violated that when it attempted to create a charter government. And Mr. Petty, the reason we're here, because nobody would listen to him. He kept telling them, you got to send this out to everybody, okay? All the electors, okay? And I want you to think about that, Your Honors. You know, pretend like you're standing in Cleveland Ball Stadium, Major League Stadium. You're standing at the plate. You got 41,000 people filling up the entire, upper level, lower level, right field, left field, everybody's there. That represents the registered voters in the city of Lorain, okay? Only 60% of them were mailed out a charter. Section 18.08 of the Ohio Constitution requires that all electoral individuals receive a copy of that charter. Everyone that was registered should have received a charter. And if you look on the actual face of that ordinance, it's patently unconstitutional because it says that you only have to mail it out to the people that voted in the last governor's election, which isn't what the Constitution requires. The Constitution requires that every elector get a copy of that charter. And despite Mr. Petty's efforts at trying to get them to correct it, it never was corrected. Even in this litigation, when you look at the answer that was filed on July 13, 2022, the answer of the city has nothing. It's a total waiver, okay? So what did the trial court do in this case? It denied his motion. It threw the case out, okay? And I say, I'm not wearing a tinfoil hat. I've been practicing law for 40 years. We go back to when Kenny Stumphauser tried to put a charter through, and we had Arlene Kokinda as the clerk, and this, that, and the other thing, and it got defeated. What we have in this most recent attempt is they put a poison pill in there. Okay, they don't like me saying it's a poison pill, but I guarantee you that if it would have passed, the Democratic leaders of the city of Lorain would have been able to go into a court and say, look, it didn't comply with the Constitution. We have to invalidate this for that reason, okay? The converse side of that is it didn't pass, but it didn't comply with the Ohio Constitution, and we have to make sure that when the citizens of Lorain decide to try to go for a charter again, should that happen, that they'll have precedent to look to say that this has to be sent out to every elector in the city under the Constitution, assuming the Constitution doesn't change. Section 18.08 was not complied with, and it's not complied with on its face. And look at, what's terrible, and I got involved in this, pretty much after the fact, but, we had 7 lawyers on this commission, and they all missed it. We had our mayor sign it. It was unanimously passed by city council. They all knew that this needed to be addressed. They ignored it. So what we have is, I don't know if I'd have to go as far as corruption, but you got to remember, the law director in this case also was responsible for the review and preparation of all ordinances.
Counsel, could we stay to whatever evidence is presented in the record or whatever is in the record if you have So I don't wanna get too far afield.
All right, okay, I
Just
understand,
in
Your
just
Honor.
argument.
Well, right, it's an argument that the Constitution needs to be followed, and it wasn't, okay? I mean, when you look at the, it says that there's no justiciable issue. The trial court said there's no justiciable issue. And I have to tell you, that how can it not be a justiciable issue on a declaratory judgment action? The Ohio General Assembly said that Mr. Petty was able to go to court and have declared the rights. Now, he's a voter in Lorain. He has a right to declare that this was not appropriate. He has every right to ask that of the court. And the court is not permitted to stick its head in the sand and say, oh, no justiciable issue because the election was lost or whatever. I mean, an election case is not moot. You've got the language in there that basically, whenever you have an election case and there's a possibility where the case or the controversy is capable of repetition, yet evading review, that's exactly what we have here. This is going to be, if we don't stop this, if we don't say you have to follow the Constitution, we're going to get this repeated over and over and over again. And it doesn't matter whether it's a Republican or a Democrat, okay, in power at the time. You got to follow the Constitution. We have to be able to agree on that.
Couldn't have been reviewed if he had filed before the election rather than after trial court?
Oh, of course, it could have been reviewed at any time, before, during, or after. I think the way that the declaratory judgment statutes read, and so, had he contacted me before the election, yeah, we could have filed it, sure, absolutely, Your Honor. But unfortunately, it wasn't until after the election that I got contacted, and they, instead of the city saying, yeah, we can agree, we're not going to ever do this again, this was a mistake, they dug their heels in and basically said, we're not going to obey what you think the Constitution means. That's why we're here, because we have to ask you to tell them that this can never be repeated. Capable of repetition yet evading review.
Counsel, can I ask you on the question of justiciability? You spoke to mootness, but can you speak to standing and why you would have standing in this case? Why your client would?
He's a voter. He's a voter, Your Honor, and as a voter, he's entitled to receive the notice of the charter so that he can read it, study it. And not only that, Your Honor, everybody else in that stadium of electors, okay, they were all required to get that notice. And you can't just give 60% of them the notice.
Was he not given notice at a particular instance, or were you just concerned that the Constitution was followed?
Both.
Even though he got notice. I'm just curious, did he get notice, or was he just, the rules have to be followed, and that's what he was concerned with?
I don't believe he received notice, and I believe he has an interest in making sure. Garon is a council watcher. He makes sure that what's going on is responsible in his opinion, and if it's not legal, he points it out. I mean, he's a valuable watchdog for the community, and we shouldn't give a pass when the government avoids honoring the Constitution. As to standing,
What about jurisdiction? Aren't election matters supposed to go to the Supreme Court directly?
no.
Okay.
No, as an election matter, in fact, the Ohio Stands Up case from the Ohio Supreme Court very clearly delineates the jurisdiction that exists in a common pleas court. And it basically declares that if you have an issue to ask for an injunction or declaratory judgment, you should start in the common pleas court. That's my take of it, Your Honor. And I'm aware of the Ohio Stands Up case because I tried to get the Ohio Supreme Court to stop Governor DeWine's poisoning the kids with them injections, and his vax lottery. That was all unconstitutional in my opinion, but they told me I didn't have standing, my client didn't have standing, that I have to start in a common pleas court. So I can tell you that very authoritatively. What we need to do in this case is we need to tell the judge that he has a duty. The trial court has a duty to rule, and he's not allowed. He's not allowed to stick his head in the sand and ignore it. He just can't, you know? And he has to follow the Constitution. And I like Jim. Jim's a great judge, okay? But you gotta follow the rule. And the rule in this case is the apex law of the Constitution. And I think, honestly, he didn't wanna call out, you know, fellow Democrats to their error. And that's what we need to do. And I cited other cases, Foster versus Cuyahoga County Board of Elections, the 8th District Court of Appeals decided in 1977. An election case is not moot. It will persist, issues will persist and are likely to evade review in the future because of inherent time limitations. The effect of construing the challenge statute setting forth constitutional limitations thereupon will be simplify future controversies and the statute. That's really what we're here for, Your Honor. We don't want this repeated in the future. We don't want another suggestion, you know, that it doesn't have to be delivered to all of the electors. We think everybody in that stadium deserves notice because the Ohio Constitution requires it. That's pretty much, I'll answer any other questions you might have.
Very well. Any questions from the bench?
And I just want to say thank you, because this is one of those cases in a 40-year career where you can actually do something of meaning to the entire city. Okay? I mean, I got 65,000 people that live in my town, and I practiced there for 40 years. And I think we need to follow the Constitution. Thank you.
Thank you very much, counsel. We will take the matter under advisement and issue a decision in due course, and we will mail, or the courts will mail that decision to you and the other party on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. So thank you very much for your presentation.
Thank you, Your Honors.